Are the glasses going to be a problem? Is there a glare or anything? Hmm?
He's in Rob's office.
Like, I wish I knew how to use it. It would be more effective. Okay, yo quiero uno, pero de aquí.
He's in, yeah, I don't know why he's in Rob's office.
¿Y de dónde te nació de fotógrafo?
¿Yo?
Ajá.
No sé. Pero me gusta.
You're very assertive as a photographer.
Yeah. Creo que sería mejor si yo sabía cómo usar esa cosa, pero como no es mío, no
It's
sé.
always helpful.
I always like talking to you on the phone in the morning. I was getting breakfast. My friend is someone like speaking. Who is that? That's so weird.
You want to start?
Yeah, okay.
Turn this on.
All right, let me just quickly introduce. Thank you all for coming. Today we have Maciel Ojeda
Yes.
from the Marcel Avila Law Group. And Maciel is going to speak to us today about VAWA in terms of immigration. Go ahead, thank you for joining us.
Thank you for having me. Good afternoon. As stated in my introduction, I'm with the Marcel Avila Law Group, having practiced with them for the last 8 years, and we are primarily a family-based immigration law office, but we also do VAWA and other types of humanitarian visas. VAWA is becoming increasingly relevant and especially important, particularly given the dissolution of DACA and other forms of relief that we had been relying on. And so it becomes important to explore with clients who may have had DACA or another form of relief that is no longer available, or for which they become ineligible, other options for relief, among which is VAWA. And VAWA, we're going to cover here is the basics. And what is involved with the basics is typically an affirmative petition as opposed to a defensive petition in front of a judge. Although we do cover those as well, that would be a topic for another day, because they do take a different shape when they are defensive petitions in front of the judge. But for today, we're considering affirmative petitions for relief in front of USCIS. And if there's any questions as to what these acronyms are, please do interrupt me, and I'll be happy to explain what they are. VAWA, itself an acronym for the Violence Against Women Act. As it relates to immigration, you will find it in the Immigration and Nationality Act, Section 204, and these subsections as listed here. And the materials will be available, and also available, obviously, looking up the Act. And they're very, very closely tied to family-based petitions. The reason for that is because they were created for people who have been spouses, children, or parents of legal permanent residents or citizens of the United States, and who have suffered abuse or extreme cruelty at the hands of those citizen or resident family members. given that these are based on these family relationships, they follow very closely priority dates, preference categories, and immediate relative designations as would apply in family-based categories, and I'll explain what those are in just a moment. So what that means in terms of eligibility when one is the spouse of a United States citizen, for example, who's been subject to abuse, is that having been able to establish that marriage, that the spouse was a citizen, and that one suffered abuse at the hands of that spouse, and getting the petition approved, one immediately then becomes eligible for adjustment of status. If the marriage was to a legal permanent resident of the United States, and the above can be proven, the petition is approved, then there's a period of wait based on the visa bulletin as published by the Department of State. So VAWA, the Violence Against Women Act, although titled Violence Against Women, is available to any man or woman in those family relationships who can show the relationship and that abuse. So it's not confined to women. That's one of the biggest misconceptions we see among our clients who come in, is that many men, many parents don't believe that they can qualify or can benefit from this because the assumption is that one must be a woman and it must be a spousal relationship. That is not true. You can be the child of an abuser or the parent of an abuser. The requirements are a bit different in those situations, but it's certainly available. So if you are the spouse of a USC, short for United States citizen, or legal permanent resident, LPR, you petition for yourself. Family-based petitions often require, well, absolutely require, that the family member with status sign the petition indicating that they have this status in the United States, this relationship exists, and that based on the law they want to petition for this family member. VAWA petitions are different in that they are considered self-petitions, so they do not require a signature or really much of anything from the abusive family member. So that's a great benefit. It does raise other issues that we'll address a little further on. So it is available to the spouse of a United States or legal permanent resident. If that spouse has children who are also without status, those children, which is understood under immigration law as an unmarried son or daughter under the age of 21, will also be included in the petition, although they will have a separate adjustment application once the time for that comes. They are included under the parent's petition. However, if for any reason the abused parent chooses not to seek a VAWA petition, the child may petition on their own, having been the victim of abuse as well. If you are the parent of a United States citizen or legal permanent resident who suffered this abuse, it is only available to parents of United States citizens, and that follows precisely with family-based petitions as typically understood. Because legal permanent resident sons and daughters cannot petition their parents, the VAWA petition is not available to parents of legal permanent residents, even if they've been abused. It is only available for parents of United States citizens. So where do you find these clients? We've had, in our practice, clients who walk in having knowledge of this particular benefit, and they ask for it, and that becomes an easy find. If they know that they've had this history of abuse, that they have this kind of relationship, and we can then proceed to ask those questions that will confirm their eligibility or confirm if they are ineligible. More and more frequently, however, what we're finding is that we find these clients based on having a really thorough questionnaire at the time of intake. So that becomes very, very important, and I would urge you to really make sure in your own questionnaires you make it a separate section so that you remember and you remind yourself and your staff to ask these questions, because having ruled out eligibility on any other basis, this oftentimes is a surprise to many people, and it doesn't require what one may typically believe is abuse. So abuse can take many forms, and USCIS, in our experience, in our practice, is really open to considering what you are able to present as abuse. So it really is a good opportunity to do some good lawyering, to sit with your client and explore and examine what are the circumstances of this relationship and what has been happening that may amount to abuse and may help you prove your case. So of course you will have those people who have been subject to abuse as we understand it. You can clearly identify it. They may have an abundance of evidence. In other situations, it's something a little more insidious. So people who may not have been physically abused, may not have necessarily been emotionally abused, but who have had their immigration status threatened by a spouse or parent or child, who've been financially abused, prevented from working, who may have been subject to cultural abuse, so things that in your or my experience we may not think of as abuse, but in their culture, in their communities, would certainly amount to that. So it's very important to take the time, particularly with these types of cases. It is not a quick interview process. It really involves asking the right questions and being in tune with your client, even at the moment of intake, to be aware of that body language, to be aware of those hesitations when they're answering questions, to see if you can explore something a little further. We've also had the experience where we've done an interview with the client, we've settled on a course of action for some available form of relief, and then well into that process we've discovered through documents that are presented in support of what we thought was going to be our petition, we've discovered evidence of abuse. And so at that point, we review it, we evaluate the strengths of that, and it becomes a matter of talking to both parties. Because again, family-based petitions, if you are starting with, for example, let's say a USC spouse petitioning for their spouse, and they were thinking of proceeding with a consular immigrant visa and a waiver, and then you discover evidence of some abuse, your representation is on behalf of both of those clients, and you cannot take any action adverse to either one of those clients, which this may be. You are presenting, if you choose to change your course of action and proceed with a VAWA petition, you may be presenting evidence that would be prejudicial or harmful to the United States citizen or legal permanent resident spouse, and so you must explain this to them and get their informed consent. So it becomes very important to have these conversations. And we've actually had that situation come up in our own practice where we were pursuing a course of action. This was discovered. We brought the clients in, explained what would be involved. Having obtained both their consents, we were then able to pursue a VAWA, which allowed them a different form of relief that was more agreeable to their particular situation. But do be aware and do be open, and do, more than anything, take the time to really evaluate, listen to those clients, try as much as possible to pick up on those subtle cues, and rely on your staff, because very often it's at the moment that they're receiving documents, that they're speaking to those clients who are dropping off documents or confirming information, that they will receive a disclosure that you perhaps haven't received. And so do be aware of all those ways in which even clients you've already established a relationship with can end up disclosing this, and it may be something to explore. And another way, obviously, to come about these clients is to directly target these markets. There are seminars, being involved in community events where discussions on knowledge of domestic abuse, abuse in general, participating in things like that, you will very often get clients or get people who have questions from there. What we've seen as well in our practice is we don't get people who have been the direct victims of this violence or who are even aware that they may be eligible for this type of benefit. But what we'll see is people sending their friends, people sending family members who they know are being abused or who have suffered this in the past, and then they will send some those family members, those friends over to inquire further. So again, being able to ask those questions and being very empathetic. This type of client requires a very different approach than somebody who may have a very straightforward adjustment of status or family-based petition, because the issues are very different. And one of the major ways in which the issues are different is in the type of evidence they can get, the circumstances they may find themselves in at the moment, because they may be in an active abuse situation. And so those circumstances may require you not only to be very empathetic and very patient, but also to have a knowledge of the other kinds of services they may need. Not that you necessarily have to provide those services yourself, but to perhaps have a referral base for other professionals who can provide those services. So what is your role then? If you can't provide all of these services yourself, what is your role as a legal advocate? You of course have to operate within the rules of professional conduct always. Having that network of other professionals who can provide those services, whether it's shelters, educational services, counseling as to eligibility for public benefits. That's another one of the big fears many of our clients have, is, am I eligible? Are my children eligible? We've seen people deprive themselves of, or deprive their children of medical benefits, food benefits, for which the children are eligible, having legal status or even not having legal status, but they may still be eligible. And they will not seek out those benefits for fear that they will then make themselves ineligible for any kind of immigration benefit. And that's not necessarily the case with this type of petition and with other petitions. So being able to counsel them in that regard. Your role as legal advocate, as I said before, really giving these clients time and patience. If you are in a position where you can give a lot of that time, then that's a huge asset. If you're in a different type of environment where perhaps there's a limited amount of time to devote to client X versus client Y, really be aware that these are the types of cases and the types of clients where a good deal of time should be allotted to hear them out and build their case. And those considerations unique to your VAWA clients. Their need for wraparound services. Therapy not just for themselves, for their children, food assistance, utility assistance, shelter, medical assistance, talking to the schools very frequently, or having a liaison. Sometimes the reports of abuse will come from the schools, or the schools have failed to report and there are mandated reporters. So not necessarily taking it upon yourself to do those, although if you can, that would certainly be a huge benefit to your client, but being able to steer them in the right direction. A lot of these clients are suffering from trauma. Some come back with official diagnoses of PTSD or other mental or emotional health issues. That will go a long way toward building your case, but it is also something to which you need to be sensitive. So speaking to these clients in a way you might speak to someone, another one of your clients from whom you're just seeking documents or just seeking information is going to be very different. It may be very painful for them to obtain the documents that are going to help you prove your case, because it is a revisiting. Even if they've been able to leave that abusive situation, if they seem as though they've overcome a great deal, and perhaps they certainly have, revisiting it in any capacity, even if it is to build this case, even if it is to ultimately get this benefit, can be very damaging. And what may be seen as a lack of cooperation and unwillingness to provide you documents should not be taken as such. It's just often very difficult and may require another conversation, another appointment in your office to really explain and offer, again, is there anything that I can help you with? If this is difficult for you, how can we work with you to help build this case and make sure we present the best possible evidence? Another situation you may encounter, and we encounter frequently, is that the victim may still be in a domestic cohabitation relationship, certainly sometimes in a co-parenting at the very least relationship with their abuser. This benefit does not require that a report have been made to the police, that there have been a conviction. It doesn't require that these partners no longer be involved with each other. And so you will have situations where your client, the victim, is still living with this person. At that point, you have to ask, is it safe for you to receive correspondence from me or from immigration to your home? Is it safe for me to leave messages for you? Is there an alternate number? So being aware of those things. Are the kids going to pick up the phone and tell mom or dad the lawyer called and the abuser isn't aware of what's going on? So do, again, add those to your questionnaires, put notes in so that you and your staff are all aware. Anyone who's sending communication, including USCIS or any other agency, is aware of the situation and that the abuser may still have a lot of access to your client. And there may also, especially if a relationship is ongoing with the abuser, there may be from your client a lot of resistance to presenting any evidence that may cast their abuser in a bad light, whether it's because they're in a continued romantic relationship with them, it's their parents, it's their child, especially very few parents want to involve their child in the criminal justice system or do anything that they fear is going to create a record of them in a bad light. And so making sure to counsel your clients that this is information that is going to USCIS, it's not required to be reported to anybody else, and that under the statute, USCIS maintains the confidentiality of everything submitted in relation to these petitions. Another consideration to be made with respect to these types of clients is their lack of access to identity and other documents. So one of the great benefits of a VAWA petition is that it takes into account that these are victims of abuse. These are victims of abuse that takes many shapes. It can be physical abuse, so that the victim is very unwilling to seek out documents from their abuser or from any other source that's going to help establish their case. It may be the type of abuse where they lack access to any documents. They were simply prevented from having any knowledge of where their identity documents might be, their children's identity documents, anything along those lines. Or there may simply be a lack of documentary evidence. This person was never allowed to go to the doctor, certainly never sought out therapy. And so at the point at which you find your client, they may not have a lot in terms of this documentation. So working with them to help create that, to help establish that, because you must at a minimum establish with USCIS the relationship, the status of the abuser, and establish that abuse occurred. And so how you go about creating that documentation so that you are presenting it to USCIS is going to be very important, and it's going to take a great deal of work with you and your client. So what are you looking to establish? What are these documents seeking to prove? So you will have to establish that the victim resided with the abuser. There's no specific length of time required for having resided with the abuser, but there must have been a period where they resided together. Like I said, a lot of these things allow you to really flex your creative lawyering muscles. We, in our own practice, have used invitations that have been mailed to the couple to get jointly. Certificates of baptism where they've both appeared as godparents, obviously bills that are joined. But again, if your client is in a situation where they've not been allowed to establish credit, where they haven't been allowed to have an account in their name, this is going to take different shapes. Perhaps their children's school records, where one or the other was the person signing off on report cards, where one was the one volunteering at the school as the Little League coach, whatever it may be, they have to show cohabitation. And if all else fails, showing mail received during the same period of time, addressed separately perhaps if nothing is joint, but showing that they did in fact live together. Evidence the applicant was battered or subject to extreme cruelty during the relationship. There does not have to be a police report. No one need be arrested. So that is not a requirement under this section of the law. But you do have to establish that there was some violence or some abuse. Physical violence, if there's evidence of that, rarely is that the case. Occasionally you will have it. If you have medical records, those are great evidence. Therapy records, we've seen letters from clergy. So if this person has an ongoing relationship or is active in their church community, it doesn't need to be from their minister or their clergyman. It can be from somebody in the same church group with whom they've had a long-standing relationship. Always any evidence, any letters, affidavits from people with whom they've had a long-standing relationship are going to go a lot further. Somebody who's been a witness or who's questioned perhaps what's been going on. Does this amount to abuse? So we saw someone who had a letter from their dentist who was doing repeated work on their teeth because of the abuse they suffered. Those letters were given a great deal of weight. So it doesn't have to be an explicit police report. It need not be pictures showing bruises or anything of that nature, but you must have something. And really evaluates the strength of that evidence. Another thing we've seen is children who are older, and even from younger children who don't yet write or don't have a great mastery of it, having done pictures showing a parent after a fight, writing letters explaining what they've seen over the years. And so those are also considered evidence of abuse. Your client must also establish that they had a good faith marriage. So they must have believed when they were married and during the marriage that it was in fact a marriage. This accounts for situations where the abuser may have been married to somebody else, which is, again, you could make an excellent argument that that itself is a form of abuse, but there have been situations where the marriage itself is not considered valid because the person was already married to somebody else. But as long as your client believed that they had entered into a good faith marriage, you must have evidence of that, then they are still eligible to apply under VAWA. Your client, or through you, must be able to show that he or she is eligible for immediate relative or preference status. And this will mean showing their abuser's legal status in the United States. You must have something to show that that abuser is either a United States citizen or a legal permanent resident. That's where it gets very difficult in some situations. Because if you're in an abusive situation, typically your abuser is not giving you a lot of access to their own identity documents, if any at all. And so what we've seen in the past is perhaps there's been another petition filed, so another family-based petition files that we can request a Freedom of Information Act for. And so we can obtain some kind of evidence that way. Anything else that may have been used. So do encourage your clients, have you filed anything else that, did you purchase a home together? Were identity documents submitted for that? Would you have access to it? Because you also don't want to obtain them in a way that's going to get your client or yourself in trouble. But you must establish that United States citizenship or legal permanent resident status. And finally, your client must show that they have good moral character. And so what we've seen frequently, more recently, is submission of FBI print requests. So the results from an FBI print request are submitted along with the I-360 petition under VAWA that goes to USCIS. Before, we were able to submit evidence of good moral character that, in our estimation, tended to show that discretion should be exercised in this applicant's favor. Now, what we've seen, even though those are submitted, are requests for additional evidence to include results of an FBI fingerprint search. So if you are going to undertake this, a good idea just to make sure you're not getting that request for evidence and you move as quickly as you can toward a final decision, just ahead of time, take those fingerprint cards, give yourself enough time before filing to get those results in, and just submit it as a matter of course with your petition to USCIS. So how to prove this eligibility? The forms you're going to need to file with this petition. Your G28, obviously your representation. VAWA is requested on Form I-360. And Form G-325A, which is will contain all of your client's biographic information. Going back about 5 years. So residence for the last 5 years, employment for the last 5 years, any residence or employment outside the United States. So in addition, having to do that, in addition to having a very detailed and thorough questionnaire, also if any of that information is not contained in your questionnaire, making sure you provide your client a separate questionnaire or biographic information sheet that they can fill out for you so that you have those ready to have those forms prepared. For your evidence of abuse, the requirements for that evidence are contained in the Code of Federal Regulations under this section, 8 CFR 204.2, those subsections listed there. And what it lists these are ideal forms of evidence. This is how it's listed in the CFR. So reports and affidavits from police, that's going to be some of the best evidence you can get. If you have that, you are well on your way. If you have a report, court records, anything from judges, that's also going to go a long way. Medical records are going to go a long way. A letter from a doctor, like we talked about, the dentist letter, who had personal knowledge of the work that was involved given the abuse this person suffered, that went a long way. Letters from school, from clergy, social workers. If there's an order of protection, whether criminally based or based on an independent proceeding, those are going to be very helpful. Typically, shelters don't give you paperwork, but if you do have some kind of paperwork from your client that shows that they sought out shelter, that's going to go a long way. Some of your clients will take pictures, or someone will have taken pictures of that abuse. If a police report was made and your client is telling you that the police themselves took pictures, find out the steps for requesting those records. Sometimes it's not a matter of just requesting the police report, it's a matter of submitting a Freedom of Information Act request to those police jurisdictions so that you get the full file of evidence they took, because often those pictures are not made a part of the report that you will get. If your client has consulted with a lawyer to obtain a divorce and has disclosed some of this information and they're willing to have you contact that lawyer, that's another way to get evidence of the abuse. And also documenting any non-qualifying abuses to show a pattern of abuse and violence. So for example, not allowing this person to work. Perhaps not explicitly stating that, but had this person enrolled in some kind of course and then were prevented from attending. Can that be documented? Is there evidence of that? So really getting creative when you don't have this ideal evidence, really speaking to your client and establishing what documents, what evidence is available. So for the evidence of the abuser status, the explicit requirements for those are in 8 CFR section 103.2 sub B. So the applicant, the petitioner, self-petitioner, must provide some kind of evidence of the abuser status. So every effort must be made to get and submit evidence of that abuser status. However, if none can be obtained, and this is explicitly stated in the Code of Federal Regulations, USCIS will attempt to electronically verify it. And in our own practice, we've actually had USCIS officers call us to let us know we're not happy with the evidence you submitted, but we are going to go ahead and do our own search before issuing you a request for additional evidence. So they actually do this, and they were able in that case to get that evidence because we never received a request for anything additional, and we did get our approval. So they do make an effort given this type of petition and the circumstances surrounding it to help the client get that evidence. So for your evidence of cohabitation, of good faith marriage, and of good moral character, aside from what I mentioned before about taking those steps to get the FBI results, any other evidence you can get to show evidence of cohabitation, good faith marriage, and good moral character, USCIS will consider any credible evidence. So really put yourself in the position of an officer reviewing this evidence, and if you feel that you would consider it credible, that it's strong evidence, it's going to be a good part of your petition. And the requirements for that under INA subsection or section 204A 1J. So the most common deficiencies in evidence that you are going to see. And we've talked about this at some length. The most common deficiency is going to be the lack or the unavailability of those documents, either given that they don't exist or simply that your client lacks access to them. Lack of official reports. This does not have to mean that you cannot proceed. This just means that there's no official report, so there's no police record, there's no court record. That does not mean that you cannot go forward. It means you have to really seek out other ways of establishing that evidence if there is in fact evidence that abuse occurred. Another not deficiency, but something to overcome certainly, is a continued relationship with the abuser. And this is more in terms of overcoming that with your client, who, if they are in a continued relationship with the abuser, may have a lot of concerns. Like I said before, they may want to preserve that relationship, whether it's for the sake of their children, for the rest of the family, if not for themselves, and really counseling them through that, what this will mean for that ongoing relationship, what this will mean for that individual. A lot of clients, if they have been subject to abuse by a legal permanent resident family member, may have very serious and well-founded concerns as to the risk to that person's immigration status. So being able to speak to them, again, within the rules of professional conduct, without also becoming an advocate for that abuser, because that's not your role at that point. Should your client become divorced? This becomes especially important if the abuser, if they're divorcing their abuser, because if a divorce does occur, now there's a clock. One is eligible to submit a request for VAWA, a petition for VAWA, even after divorcing, as long as it's not submitted before 2 years have passed. So once someone's divorced and 2 years have gone by, no longer eligible to file an I-360. Should your client remarry? Having been divorced, they get their petition in on time before the 2-year mark. They cannot remarry until you have an approval of that I-360. Remarriage before an approval, and you're done. If the abuser's status is terminated, so if you have an LPR spouse, and they have, because let's say they have a domestic violence conviction, they have their LPR status revoked, or they are placed in removal and are ultimately removed, that does not prevent your client from continuing to seek out that status. What they have to show is that at the time of the abuse and the time of the filing of the petition, that abuser had that status. Should the family relationship end before the time of the filing or while the petition was pending, that's going to be evaluated based on your client and the type of family relationship under which they're petitioning. Like I said, divorce has its own set of rules. Remarriage will have its own set of rules. If it was an adoptive relationship and for some reason the adoption is going to be dissolved, that will have its own set of rules as well. So should there be an end to that relationship, that has to be evaluated on a case-by-case basis, but it should definitely signal something that this requires further evaluation, because that can certainly affect your filing. And as with most other family petitions, the aging out of children is certainly going to be a factor, particularly where those children don't have their own separate I-360s VAWA petitions filed. So if you have a situation where you have a minor child who's included in their parents' I-360 petition and they are about to reach age 21, they will age out of the petition. They will no longer fall under parents' petition, and so do be aware of those age out requirements. At that point, if there's evidence of abuse to them, they would have to consider, and you would have to advise them on seeking their own independent I-360 petition. And so how to overcome the weaknesses in that evidence. We talked a lot about taking the time with these clients, really having a good and thorough intake, really being aware and empathetic and open to reading the nuances in your interactions with those clients, and helping them craft a narrative. Part of this petition is going to be a narrative from your client, detailing the abuse, the harm they suffered, particularly where it wasn't what one might consider very clear evidence of abuse. Really explaining, this is the client's opportunity to really give a personal voice and feel. Everything else we're submitting is on a form. It's documentary evidence. This narrative is really their opportunity to put their face on this to the officer. So really helping them craft that. You will have some clients who are excellent at doing this. You will have others, for whatever reason, don't find it as easy, either because it's just not something they're used to doing, or it becomes too traumatic to really revisit, and so they are unable to do it. Your own narrative. So what we do in our practice is not necessarily required. What we like to do is include, if not a memorandum, then certainly a very detailed cover letter, laying out our case, why we believe this client is eligible. And beyond those eligibility requirements, really crafting our own narrative and explaining that their eligibility as well. And it gives us another opportunity, again, to put a human face on this petition. Weaknesses can also become in your own relationships with other professionals. So, for example, we have 2 or 3 counseling services from whom we've received excellent assessments. We are familiar with their work. We're familiar with how they relate to and treat clients. And so we are very confident in, if clients do ask us, where can I go? We are confident giving them that information, leaving it up to them, of course, to evaluate and make the ultimate decision if they will undertake services from those people, but having a base from which you can confidently draw to direct your clients, and knowing that you're going to get good assessments that are going to be received well by USCIS. And your client's own existing relationship with witnesses, with their children who may have been witness to abuse, neighbors, friends, family. They can really ask those people, even if the abuse has happened in the past and it's no longer ongoing, they can always go back and say, do you remember? If those friends, family members, children, parents are willing to provide those letters, to provide an affidavit, then that's also going to go a long way as direct evidence of the abuse. So the process itself. After your I-360 has been filed, you've done your forms, you've gathered the best possible evidence you possibly can. It is submitted. After it's submitted and been evaluated by USCIS, the first step, usually, ideally it's an approval, but there's often intermediary steps, and so the first step after submission would be a prima facie determination of eligibility. And so it entitles your client to limited public benefits. It is not a status in and of itself. So they are not lawfully present as of the time of the determination, but they are eligible for certain benefits. You can explain that to them, and the notice itself does advise them of that. So after receiving that, if they want to apply for a medical card, for food benefits, anything of that nature, the notice, the prima facie determination itself will have an explanation. That may also require further explanation to those agencies providing those services, so do be prepared for your client to come back and say, you know, they told me I didn't qualify, and advising them of that and how they are eligible. And this prima facie determination may be extended until you get your final I-360 decision. So, and the notice itself again will tell you the period of validity and when you should submit a request for an extension. So this is what a prima facie determination looks like. It will come on, the form itself is titled I-797, but here, can you guys see that well? Okay. The case type, the date you submitted, the notice date, and establishment of prima facie case. So the client will receive one, you will receive another. And it lets you know it's valid for a period of 180 days from the date of the notice shown, and that a request for an extension must be submitted. And here is the expiration date. And so typically what you want to do, calendar it, I would say at least 30 days before the date of expiration, because they want to receive a request for an extension at least 15 days before it expires. You can submit it before then. And it's a very simple request for an extension. There's no particular form required. It's just a cover letter, a copy of your existing determination, and a request for that extension. And so the processing times for an I-360. USCIS is very kind, and it has these processing timetables, which you will find. You can navigate here. Here's the website. And once you navigate to that website, they have 4 or 5 different service centers for which they publish processing times. The service center in charge of reviewing requests for VAWA petitions is the Vermont Service Center. So in the drop-down menu, you would select Vermont Service Center. And what will be generated is this processing chart. And you would just, it's not very clear on there, but all the way to the left is the form number. So you would look for the form number, and then this will just give you a description of what the form is. And all the way to the right, they will have dates. And those dates are the dates of those petitions that are currently under review. So you will get an idea of about how long, based on the date of your own submission, you have to wait, or your client has to wait for a decision. So once you get an ultimate approval, what does it get your client and what does it not get your client? So having gotten the I-360 approval, your client is eligible for work authorization, so you can then file an I-765, which is the form number under which you request employment authorization. They have, again, eligibility for limited public benefits. And once they've applied for the employment authorization, having gotten that then entitles them to apply for a Social Security number, but only once they've gotten that employment authorization. What the I-360 approval does not give is any kind of guarantee of an approval of an adjustment of status, which would be the next step in the process to acquire permanent resident status based on a VAWA petition. So this is a VAWA approval, the I-360 approval. And some important sections there. Here, our first red circle tells you the priority date. And here it lets you know the type of petition. So this is the approval notice for a self-petitioning spouse of United States citizen or permanent resident. This particular petition was received on September 16, 2013. This becomes important if you are in a preference category. So we talked in the beginning about how these types of petitions follow closely family-based petitions. When, under immigration law, when one is the minor child or spouse of a United States citizen, having gotten either an approved family-based petition or an approved I-360 VAWA petition, you can then proceed immediately to file an adjustment of status application, which is what gets you permanent residence in the United States. If you are the child or spouse of a legal permanent resident, or the child or spouse of a legal permanent resident, and you get your I-360 approval, you cannot proceed to immediately file for adjustment of status. There's a period of wait based on your country of origin. And so, when can your client file for adjustment of status? Let me go back to the others. So, and again, reassure your client after having gotten the approvals that USCIS will maintain the confidentiality of all filings and supporting documents. So even if what you get at the end is not an approval, those documents that have been submitted are not going to be disclosed to the abuser, they're not going to be sent back, everything remains confidential, as per USCIS regulation. But when can your client, if they cannot immediately proceed to file an adjustment application, when will they be eligible? Like I said, United States citizens, spouses, children, and parents can file immediately for adjustment of status. Minor children and spouses of legal permanent residents or adult sons or daughters unmarried of legal permanent residents have a period of wait. And that is determined by looking at both the priority date on the I-360 and then the visa bulletin. So on our approval notice that we just saw, that priority date was September 16, 2013. Assuming that our applicant was from China and they were the spouse of a legal permanent resident, we would then go to the visa bulletin for the current month, look under China. F2A would be the category for spouses of permanent residents, and if the date listed here is later than the date on the priority date on our petition, then that person is eligible to apply for permanent residence. If it is the same date as our petition, then they are not yet eligible. So, for example, our petition was filed on October 22nd, 2015, and our client is from China. They're not yet eligible because this date has to be later than the date on our petition. Our client wouldn't be eligible until the date here was October 23rd, at least, 2015. And it's different for these different countries. So all other countries except China, India, Mexico, and the Philippines, which have their own dates. But once your petition is current, the term we use, the priority date is current, then those clients may proceed to file an adjustment of status application. So adjustment of status under VAWA, what it looks like. The forms you would need for the adjustment of status is G28. You're going to want a copy of your I-360 approval, the I-485. I'm going to skip the I-64 just briefly. I-693, which is a medical, which you as an attorney would not fill out, but you would advise your client that that is the form that the civil surgeon, the doctor, has to fill out and provide to them in a sealed envelope for submission. And the I-765, which is a request for employment authorization. And then the civil documents they need to submit: passport size pictures, copies of birth, marriage, death, divorce certificate as applicable, and any certified dispositions of arrest. So if your client has been arrested, even if it's for driving without a license, for minor offenses which resulted in an arrest, which oftentimes happens for our clients, they must provide you with a certified disposition of that arrest. And if they've been active in the military, any military records. They must also include either the USCIS fee for an adjustment of status, which is currently $1,225, or you must submit on Form I-192 a request for a fee waiver. And there are currently 3 bases on which you can request a fee waiver. That is either that your applicant, your client, is themselves receiving public benefits, means tested public benefits, or that the household member filing their taxes as head of household is receiving public benefits, that they make less than 150% of the current poverty guideline, or that paying the fee, you have to establish that paying the fee would cause them an undue financial hardship. Those are the 3 bases on which you can request a fee waiver. So grounds of inadmissibility of which to be aware. So even if you've gotten your I-360 approval, you're ready to go to adjustment of status, do be aware crimes may make your client ineligible for receiving legal permanent residence in the United States, notwithstanding their having already received an approved I-360. Periods of unlawful presence, particularly if your client departed the United States after certain periods of unlawful presence in the United States, may make them ineligible for lawful permanent residence, unless in some circumstances a nexus, a clear nexus between their either crimes or their periods of unlawful presence can be shown to their abuse. So if, for example, your client was convicted of being an accessory or having committed 2 burglaries, but they did that as a result of the abuse they suffered, so they were made to participate in this. If that can be shown, then your client may be able to overcome that and still receive a grant of permanent residence. If there is no nexus, however, between that crime and the abuse they suffered, your client may very well be ineligible. So do be aware of those issues. Fraud. If at any point your client has committed fraud, and particularly in order to seek an immigration benefit, they may be ineligible. However, a waiver does exist. If your client can show that extreme hardship to themselves, a U.S. citizen, or legal permanent resident parent or child would result, then there's a waiver available under Section 212I of the INA. And so at that point, it would be a matter of not only filing for an adjustment of status, but also beginning to prepare for that waiver and gathering the documents that are going to show extreme hardship either to your client or to these family members, so that a waiver can be granted. An important note, particularly for those clients who have an ongoing relationship with their abuser, whether it's their parent, child, or spouse, if they are ultimately granted permanent resident status as a result of this VAWA petition, they are not allowed to later file for that abuser's lawful status, whether that abuser has lost their status and they are now seeking to acquire a new status. It cannot be done as a basis of a petition filed by the victim of their abuse. Citizenship. So when will your client be eligible for citizenship? Your client, depending on if they are the spouse of a United States citizen versus any of the other relationships, so a spouse of a legal permanent resident, a child of a United States citizen or legal permanent resident, or the parent of a United States citizen, will have different periods of eligibility for filing for citizenship. If the fastest being, if you are the spouse of a United States citizen, then you are eligible to apply for citizenship within 3 years. All the other after having acquired lawful permanent residence. So you've been a lawful permanent resident for 3 years, you can then file for citizenship. If you fall under any of the other family categories, it would be a period of 5 years. And that would be, citizenship is the ultimate goal in any of these. So having gone through the requirements and what you can anticipate what might be the hiccups in a lot of these petitions, and really the importance of counseling and being able to understand and communicate and really empathize with these clients, what's really important as well in so many of these cases is your own self-care. Because so very many of these cases are very, they're harrowing, to be very honest. You see and hear from not just your client, but sometimes from their very young children, from their parents, from neighbors, and they present pictures and other evidence. It gets very overwhelming. And so it's very important to, after you've spent 1 or 2 or 3 hours with your clients, getting this narrative out, going through their evidence, talking them through it, of really taking some time to reflect and to get yourself back together, because you cannot, as their advocate, obviously lose yourself and lose control or cry with them necessarily, but it does get to you after a while. And so giving yourself enough time and to really regroup. And so if that, a lot of, in our office, we kind of, with our our support staff, if at all possible, we bounce these ideas off each other. We kind of share in these narratives and this evidence, and there's been a lot of support just amongst ourselves to recognizing how difficult these cases can be. A lot of people meditate, that time for self-reflection, but very important to take some time and step back and give yourself time to kind of recover from hearing these stories and to be able to come back and get back to the task at hand, not just for this client, but for your other clients as well. So having gone through all that, I'd like to ask if there are any questions. Hmm?
Going back to the grounds of indisability, you mentioned for crimes, unless you could show a nexus between the crime and the abuse, then the person may not qualify for adjustment.
Right.
But could the applicant possibly provide like a 212H waiver, or is that not applicable to the adjustment? Because sometimes with like I-130 petitions, you can provide like a 212H
Certainly.
waiver. So is that not the case with this type of adjustment?
Certainly. At that
Just
point,
repeat the question.
of course. So the question was, we discussed grounds of inadmissibility, particularly crimes, and that unless a nexus between the crimes for which the client has been convicted can be shown to the abuse, they may be ineligible for legal permanent resident status. And that's very true. A 212H waiver may be available in limited circumstances. Again, 212H is limited in terms of its availability, but certainly something to evaluate, because absolutely it need not just be a 212I, or the nexus doesn't necessarily need to be shown if a 212H would be applicable. But at that point, you would have to anticipate certainly preparing that waiver,
Right.
but then ultimately seeing what the officer is going to require.
And then I have a second question.
Sure.
You said that while they are, or once the prima facie determination has been made, they get limited public assistance. So when you say limited, what don't they qualify for? What do you qualify for?
Well, it depends on the agency. What generally they're eligible for is any means tested public benefits. So if they can show, typically those are based on income requirements,
Okay.
so they would be eligible for those. And anything that's going to go, like medical cards, food benefits, anything that's kind of for basic needs,
Okay.
they're going to be eligible for. Any other questions? And I did want to go back. I know I said I was going to skip that and then go back to it, and then I didn't go back to it. For one of the forms for the adjustment of status, which is an I-864W, that is for an affidavit of support, which is typically required in any adjustment of status application to show that you will not become a public burden. And so when it's a family-based petition, that's filed to show that your petitioner will assume financial responsibility so that you don't become a public burden. VAWA applicants are exempted from having to show that, but they must still submit the I-864W, which is an affidavit of support waiver, to show that they are exempt from that requirement.
All right, well, thank you very much.
My pleasure.
Just before everyone kind of wraps up, I just want to let you know that we have a couple other seminars coming up here at CVLS. There's a child representative training on October 19th. There's a GAL for minor training on October 24th. Our monthly new volunteer orientation is November 1st, so if you know of any other attorneys that are not involved with CVLS and might be interested, they could join us for the orientation. And our next immigration CLE, and the series that we're presenting will be November 9th, which the topic is Asylum Law Demystified. So, and there's also a little evaluation sheet, if you can fill that out and just either leave it on the table or at the table by the door before you go. Thank you all for coming.
Thank you, thank you.
Thank you, Marcel.
Thank you.
Great presentation.
Thank you so much.
Good question.
Oh, thank you. Kathy, am I leaving this with you or?
Okay, yeah, I can take it. Thank you.